The First 100 Years campaign aims to raise awareness of the first women to enter the legal profession. I'm now joined by Katie Broomfield, a researcher at Royal Holloway, University of London, former barrister and champion of the First 100 Years campaign. Katie, what obstacles did women face in trying to enter the legal profession?
Well, it definitely wasn't a lack of ability or education. In fact, women had been reading law at university from the end of the 19th century, and the first woman to graduate in law was Eliza Orme from the University of London in 1888. And interestingly, at this time, you didn't actually need to have a degree to study law. The biggest obstacle that they faced was from male members of the profession who didn't want women to join. And they raised lots of arguments against women joining the profession. They wrote to the newspapers and said that women were too illogical, they were too prone to gossip to make good lawyers, and that they weren't as trustworthy as men. At the bar, there was the fear that women would somehow use their feminine wiles to sway a male judge and jury, because obviously at this time juries are all male, and that the chivalrous barrister would be unable to press his case when faced with a woman opponent. Solicitors, on the other hand, they argued that their profession was already overcrowded and that they didn't therefore want lots more potential competition. And I think that's quite interesting because, and there's a really good quote from one of the women who does try to join the profession, and she points out that these arguments that women are too illogical and that the profession is overcrowded are actually mutually exclusive. And what they reveal is that really what the male members of the profession feared was competition. They knew that women would be more than capable of succeeding as lawyers, and so they did everything that they could really to prevent them. So every single application made by women to enter the profession before 1919 was rejected by the Inns of Court, the Law Society, in the courts, and here in the Houses of Parliament.
How did women challenge these barriers prior to the Sex Disqualification Removal Act?
So in order to practice as a barrister, you had to be a member of one of the 4 Inns of Court, and to be admitted as a solicitor, you had to pass the Law Society's examinations. And the Inns of Court and the Law Society resolutely refused to admit women before 1919. So some women, like Eliza Orme, she set up her own firm and she worked for other lawyers on legal matters, but not as a lawyer herself. And other women campaigned. So the 1919 Act is the result of a decades-long campaign by women to be admitted to the legal profession. And the first women applied to the Law Society and the Inns of Court from about the 1870s onwards. And then at the start of the 20th century, things start to step up a little bit. So in 1903, for example, Bertha Cave applies to be admitted as a student member of Gray's Inn for the purpose of being admitted as a barrister. And Gray's Inn refused her application, and she appeals that decision, which is, the right that she has, to the House of Lords, and argues her case before a committee in the House of Lords herself. And they uphold Gray's Inn's decision and say no, women can't become barristers, can't be admitted to the Inns of Court. And then in 1913, we have what's become something of an infamous case. It's Bebb and the Law Society, and there are 4 claimants, but Gwyneth Bebb's case is taken as the test case. And the women are challenging a refusal by the Law Society to allow them to sit the preliminary examination with a view to being admitted as solicitors. And the question the Court of Appeal has to decide in that case is whether women are persons for the purposes of the Solicitors Act 1843. And what the court decided is that actually women aren't persons, and that in 1913, despite acknowledging that Gwyneth Bebb is inherently capable and probably more competent than many of the male members of the profession who will sit the exam, because she's a woman in 1913, she can't be a lawyer, a solicitor. So women have applied to the professional bodies. They've challenged those decisions in the courts. So the next step, in 1914, a committee is set up for the admission of women to the legal profession. And there have been bills and proposed in the Houses of Parliament before, but they really start to push for legislation. And several bills are introduced, and it has to be said that there is some support within the profession for change, and there are motions proposed at the Bar Council and the Law Society, but they never really get anywhere. As well as lobbying for legislative change, women do also continue to apply to the Inns of Court. So, for example, Helena Normanton applies to be admitted to Middle Temple, and what the women do is that they use the newspapers. So lots of women who want to be lawyers, they write articles for newspapers and they write letters, and there's quite a lot of reporting on this subject. Lots of it quite favourable, actually, and there's a lot of support outside the profession for women to be admitted. But then by 1919, there are 3 bills on the question of women being admitted to the legal profession being debated in Parliament. And this is one of them. So this is the Barristers and Solicitors Qualification of Women Bill. This is unsuccessful, and the bill that is eventually passed is the Sex Disqualification Removal Act. It's passed on the 23rd of December, and Helena Normanton becomes the first woman to be admitted to an Inn of Court on the 24th of December 1919.